without further ado, may I just turn over to Professor Tang for his views on the same topic in Singapore, please.
Right. Thank you very much, and thank you to Lutz, Stephen Gallagher, and Bonnie Young, and friends of CUHK for organizing this wonderful conference. I'm honored to be speaking to you on the role of unjust enrichment in Singapore, and let me try to share my screen with you in relation to my PowerPoint. It doesn't seem to be working. I think you have to assign me to be the participant. Okay. Okay, this seems to work. Right. So if I may begin, I'm keenly aware that coming from a small jurisdiction and looking at the law of unjust enrichment, it may not be of much relevance to a lot of you. But so in this paper, what I try to do is I try to draw on the larger theme from this paper that might make it interesting for you. The larger theme that I'm trying to draw from this paper is that I think that this paper serves as a case study of how the laws of England has been adapted in Singapore. And in looking at, because essentially Singapore law is derived from English law. And in looking at this, the law of unjust enrichment in Singapore, I resist using the lens of legal transplant, which I find is a term which is has a lot of baggage. And instead, my theoretical framework, which I employ today, and in this paper, is to look at laws travels or laws itineraries, which I draw from a legal historian, Dr. Iza Hussein. Who talks about the travel of law, and basically her framework, and this framework which I employ, is that is indicative of two phenomena, i.e. the analytic project is not that simply laws travels, and coming from a jurisdiction like Singapore and many of other jurisdictions as well, we know that law travels, but how it is transformed or how it stays the same when it goes to another jurisdiction. The second phenomena that I want to explore is this idea of circulation, law as a circulation of ideas, and that the transfer or the law's travels is not just a linear transfer, but somehow when it is transferred to another jurisdiction through the circulation of ideas, it changes. And the idea of circulation of ideas come from circulation of ideas found in the judgments in the common law, and not just judgments in the common law, but through the work of academic scholars. And we see that the law of unjust enrichment is greatly influenced by the work of academic scholars. Now, in terms of Singapore's private law jurisprudence, and here I stress that I'm looking at the private law jurisprudence and not the public law jurisprudence, because the public law jurisprudence has developed in a particular way. The private law jurisprudence in Singapore is very international. In fact, in a speech or in an extrajudicial essay by Justice Andrew Pang, writing on contract law, he says that the proper jurisprudence in terms of contract law, and I would think that his analysis would be applicable when he looks at unjust enrichment law, is echoing Lord Gough's famous speech that this is essentially a search for principle. That when we develop a new area of law, we are searching for principles. And where do we search for the principles? And this part, at least, is interesting for, I think, comparative lawyers, is that the search for principle is across jurisdictions, across judgments from all Commonwealth jurisdictions. And also, I think, Justice Andrew Pang stressed on academic literature as well. Now, in terms of Singapore's jurisprudence on unjust enrichment law, I think that it follows what our Chief Justice Sundaresh Menon talks about, an idea of adoption with adaptation. Basically, the structure is similar to English law, but there are various adaptations that has occurred. And again, echoing Chief Justice Menon, who is the Chief Justice of Singapore, he talks about, and this is a speech that he gave in the English commercial bar. He talks about this idea about the common law being international and whether the work of the Singapore courts, for example, would percolate into the groundwater of the common law and influence not just and influence jurisdictions outside the Singapore. So this is an interesting idea of how I see the common law working as perhaps a global set of laws which provides technical know-how. So with that, let me now unpack the role of unjust enrichment law in Singapore. And here I have, I think in 20 minutes, I don't have time to analyze the minutiae of the doctrines. And I identify six major roles of the law of unjust enrichment in Singapore. I think in Singapore, it's recognized that unjust enrichment is a distinct branch of the law of obligations alongside contract and tort. It operates mainly in situations where transactions or enrichment is transferred in circumstances where the transferor's intention is vitiated. In Singapore, we have recent pronouncement that clearly states that we subscribe to the unjust factor approach and not the absence of basis approach. The law is also quite clear that unjust enrichment principle may only operate where there is no contract, and I think that draws from the discussion that echoes a discussion by Liu Chiao when he talks about that point in the Chinese law. It seems that Singapore law is also subscribes to the principle that unjust enrichment law may only operate where there's a direct transfer from the plaintiff to the defendant. And here we see some divergence from English law that unjust enrichment law may also operate where there's an illegal contract, provided there is no stultification. And I'll expand on that. The stultification point is a point which was drawn from Professor Peter Bergs and adopted by our Singapore Court of Appeal. So the first point I think is quite obvious, and this is from the decision of Justice of Appeal Andrew Pang in Turf Club decision, where he was very clear that unjust enrichment is a separate cause of action. It sits along contract and tort. It's a distinct branch of the law of obligations. Justice Andrew Pang. So Justice Andrew Pang was a contract scholar before his elevation to the bench. And he draws, again, a lot from academic work. He makes it quite clear that the rationale of the law is not based on implied contract, and there's the usual criticism of artificiality in terms of implied contract to explain unjust enrichment law. Now, Singapore law subscribes to unjust enrichment law based on the unjust factor approach and not the absence of basis approach. And also, I think the judgments make it very clear that just because something is very unfair, it doesn't mean you have an unjust enrichment claim. And this came out very clearly in this case called the Anna Wee case. And I'll just go through the facts very, very quickly. Now, in Anna Wee's case, Miss Anna Wee was a very wealthy lady. She married somebody who was not, she thought wasn't very wealthy. The marriage fell apart, and when it fell apart, they got divorced. Miss Wee didn't ask for any division of matrimonial property. So she didn't ask for division of matrimonial property, but when her late husband passed away, and when the will was read, she found out that actually the late husband was not a pauper. He had hidden $20 million on offshore trusts opened by BNP. So she was very hard done by. She sued BNP, and one of her claims was for unjust enrichment. And she said how, she was treated so badly by her late husband. It's so unfair, it's so unconscionable, etc. And she sued inter alia in unjust enrichment. Now, there are two difficulties with Ms. Wee's claim in this claim against BNP, because the first is that her claim for unjust enrichment had a problem because was there an enrichment at her expense? Singapore doesn't subscribe to a community property regime, i.e. when you're married, you have a community of property, and therefore the money came from her late husband and not her. And that was the difficulty that she faced. Another difficulty that she faced was that what is the precise unjust factor that she's alleging against the bank? And she couldn't identify the unjust factor, and the claim was therefore dismissed. And Andrew Phang, Justice of Appeal, Andrew Phang was very clear to say that unjust enrichment in Singapore is not based on the general notion of unconscionability or unjustness. And therefore, I think it feeds into what we heard earlier from Professor Martinique, that unjust enrichment itself is not a wide-ranging principle. It's weakly normative, and it seems to be rather acting as an organizing concept as to what the case law tells you. Now, in terms of this idea of absence of basis, which is a civilian influence concept, and also we know that Professor Peter Burks had mooted this in his last book of absence of basis. This has been argued, I think, numerous times in Singapore. And one example of this, the absence of basis approach, how it could be different or lead to a different outcome, is the case of Tanaka Lumber and Datuk Haji Muhammad. Now, Tanaka Lumber was this case where certain monies were transferred to the defendant directors. All right. So a company called Tanaka had transferred certain monies to the defendant directors. The defendant directors said, the money was given to me beneficially, so it's mine. Tanaka, the company, said, no, the money was given to you to hold on trust for some of my investments. So they went for trial before the High Court, before Judicial Commissioner Edmund Liao. Now, Judicial Commissioner Edmund Liao disbelieved both sides. He says, well, I don't really believe you, Tanaka. Your evidence is no good. But on the other hand, I don't believe you, the first defendant, that the money was given to you beneficially. And he dismissed the claim. Now, absence of basis may arguably operate in this case, because it's undisputed that money was transferred. Doesn't seem to be any basis for this argument or transfer, and this is precisely what was argued in the Court of Appeal. But the Court of Appeal dismissed this without grounds, wasn't very keen of this absence basis argument. And in my paper, I give you I trace some decisions where absence of basis was actually discussed by the Court of Appeal, Singapore Court of Appeal, and eventually not adopted. So Singapore adopts the unjust enrichment or unjust factor approach and not the absence of basis approach. Now, the other role of unjust enrichment, or something that limits the role of unjust enrichment, is, I think, the recognition that unjust enrichment is subsidiary to contract, and that if there's a contract conferring the enrichment, there cannot be the operation, or unjust enrichment simply cannot operate. And this is illustrated by our Singapore case of IDA and SingTel. Now, IDA and SingTel is a case where the government regulator, IDA, was negotiating with SingTel, the largest telco company in Singapore, for the modification of certain telco licensing. So this was way back in the time where we only had one single telco in Singapore, and the telco was SingTel, who had paid a lot of money for the license. So IDA, the regulator, wanted to free up the market by having more telcos, and obviously it had to compensate SingTel for modification of the telco licensing. Now they were negotiating on this modification, and eventually they came up to a payment of $1.5 billion that was paid to SingTel. Now, IDA's argument, or IDA's thought process, or that they allege, was that in coming up to the $1.5 billion, they assumed that it was taxable, and they had grossed up it to 26% corporate tax, and that represented Singapore $388 million. Subsequently, after they paid, this was not communicated to SingTel. This was unilaterally done by their accountants. And what happened subsequently was that SingTel argued with the Inland Revenue Authority of Singapore to say that, look, this is not taxable because this is not income, this is a form of compensation, and they succeeded. Because after they succeeded, IDA, the government regulator, was very upset and then sued SingTel for unjust enrichment. And they claimed, look, we've made a mistake. We thought it was taxable. We've made a mistake of law, but it wasn't taxable in the end. So they went to court, and ultimately this claim was dismissed by the late Justice Lai CUHK because he found that there was a valid contract of compromise. Again, drawing from Liu Chiao's discussion, there's a valid contract of compromise, and the valid contract of compromise would include the taxable element in relation to the tax component. Now, I have 5 minutes more, so let me go through with you the last two rows, which is unjust enrichment only operating if there's a direct transfer. And I would illustrate this using the case of Alwi Handoyo and Jong's Very Sumito. So in Alwi Handoyo, in this case, a very unusual case, there was a contract for sale of Indonesian shares between a company called Antique and Mr. Jong. Now, it was contracted in this contract that Antique, the purchaser, would pay $6 million to certain offshore companies. And this was in the contract. It wasn't very clear what the $6 million was. And somebody explained to me that when we're dealing with Indonesian sale contracts, sometimes payment to third parties is quite common. All right, so Mr. Jong sold the shares. The $6 million was paid to the third-party offshore companies, and Mr. Jong was very unhappy about this. And then he sued the third-party offshore companies, and he sued the controller of the third-party offshore companies for unjust enrichment. And the difficulty with his claim was that the enrichment, the first point is that the enrichment did not come from him. All right, the enrichment actually came from Antique, and there's no direct transfer of value from the plaintiff, Mr. Jong, to the third-party companies. So that's one problem. The other problem is the contract provided for the payment to the third-party offshore companies. And therefore, again, there is no unjust factor here. So in my remaining 3 minutes, let me just very quickly explore the role of unjust enrichment and illegality. And in England, we have a big case by the UK Supreme Court. We know that the UK Supreme Court has used the range of considerations approach in dealing with illegal contracts. In Singapore, we have the leading case is the Ockroyd trading case. Now, the Ockroyd trading case is essentially in two stages. The first stage is that we determine whether the contract has been avoided, whether in common law or in statute. Now, even if the contract has been avoided in common law or statute, it is possible for the contract for an unjust enrichment claim to be successful as long as, and this is what Justice Andrew Pang adopted from Peter Berks's work, as long as it doesn't stultify the reason why the contract is illegal in the first place. So, and I think here is this idea of the circulation of ideas, especially from academics, which shows that how the law has been influenced by academic development. I think that is all I have for my presentation, and thank you very, very much.
Well, thank you so much, Professor Tang, for that very comparative and also theoretical discussion on the situation in Singapore. So.